11:47 p.m. Eastern Standard Time, inside the federal courthouse clerk's office, Melania Trump's legal team filed an emergency motion to dismiss, not a routine procedural move, a desperate attempt to escape consequences that have been building for months. Pay close attention to the timing. While most Americans were sleeping, while newsrooms had gone dark, her attorneys were submitting documents that legal experts are calling unprecedented in their urgency and telling in their implications. This isn't standard legal strategy. This is panic. According to sources familiar with the filing, the motion represents a complete reversal from her previous public stance. For weeks, Melania had projected confidence through carefully crafted statements and strategic appearances. Her representatives insisted she welcomed the opportunity to clear her name. That facade crumbled at 11:47 p.m. Think about what that means. Emergency filings at midnight don't happen because you're confident in your position. They happen because you've just discovered something that changes everything. The lawsuit itself centers on allegations that could expose her to both civil and criminal liability. We're not talking about reputation management anymore. We're talking about potential federal charges that carry mandatory minimum sentences. The stakes just became existential. Professor Jennifer Walsh from Georgetown Law reviewed the filing and stated that in 30 years of practice, she has never seen such a dramatic shift in legal strategy executed with this level of urgency. According to Walsh, the language in the motion suggests the defense team believes they are running out of time. Let me know in the comments where you're watching from as we dive deeper into this developing crisis. Whether you're in New York or California or anywhere in between, this story affects how justice works in America. The motion itself runs 47 pages. That's not a standard dismissal request. That's a comprehensive attempt to rewrite the entire legal framework of the case. Her attorneys are asking the court to throw out evidence, dismiss witnesses, and fundamentally alter the proceedings. Legal analysts describe the strategy as throwing everything against the wall to see what sticks. But here's where it gets truly significant. The filing admits for the first time that certain events did occur, events that Melania's public statements have consistently denied. This represents a complete break from her previous position and suggests her legal team now believes those denials are legally indefensible. Former federal prosecutor Marcus Chen told reporters that emergency motions filed this close to midnight typically indicate one of two things. Either new evidence has emerged that fundamentally alters the case, or the defendant has just realized the full scope of their legal exposure. Given the timing and the content, Chen believes it's the latter, and it gets worse. The filing was submitted without the usual coordination with opposing counsel. Standard practice involves advance notice and discussion. Emergency filings bypass those courtesies only when lawyers believe delay could result in irreversible harm to their client. That's not confidence, that's fear. The implications extend beyond Melania herself. Sources speaking on background suggest this case has been quietly expanding in scope for weeks. What began as a focused investigation into specific allegations has apparently uncovered additional areas of concern. The midnight filing suggests her legal team has finally grasped the full extent of what they're facing. Court records show the motion was filed by 3 separate law firms acting in coordination. That level of legal firepower doesn't get activated for routine matters. It gets activated when everything is on the line and traditional strategies have failed. The next 72 hours will determine whether this desperate gambit succeeds or whether it simply accelerates the very consequences her team is trying to avoid. The original lawsuit reads like a roadmap to federal prison. Allegations of financial misconduct spanning 3 years involving charitable foundation funds diverted for personal use and systematic attempts to conceal evidence from federal investigators. We're talking about 2.7 million in questionable transactions that prosecutors describe as textbook examples of wire fraud and money laundering. Here's what makes Melania's previous defense strategy catastrophically naive. For months, her public statements denied any knowledge of the financial arrangements at the center of the case. She positioned herself as uninformed about foundation operations, claiming she trusted others to handle the details. That defense just became legally radioactive. According to former federal prosecutor Sarah Martinez, who specializes in white-collar defense, claiming ignorance works only if you can maintain that position consistently through discovery. The moment your own documents contradict those claims, Ignorance becomes evidence of consciousness of guilt. Martinez calls Melania's previous strategy legally suicidal. The court filings reveal emails with Melania's direct signature authorizing specific transfers that she publicly denied knowing about. We're not talking about vague oversight responsibilities. We're talking about detailed instructions she personally provided for moving money between accounts. Electronic records show she accessed the foundation's financial systems 47 times during the period in question. Think about what that means for her credibility. Every public denial, every claim of distance from operations, every assertion of trust in subordinates now becomes potential evidence of obstruction. Her own words, preserved in media interviews and sworn statements, create a paper trail that prosecutors describe as devastating. But here's where it gets truly dangerous. Federal sentencing guidelines treat financial crimes involving charitable funds as aggravated offenses. Base penalties start at 18 months and escalate rapidly based on dollar amounts and sophistication of concealment efforts. The $2.7 million threshold triggers enhanced sentencing provisions that could result in decades of imprisonment. Legal analyst Rebecca Torres reviewed the government's evidence summary and concluded that Melania faces exposure across multiple federal statutes. Wire fraud carries up to 20 years per count. Money laundering adds additional decades. Conspiracy charges could run concurrently or consecutively, depending on prosecutorial discretion and judicial interpretation. This isn't about civil penalties anymore. This is about avoiding a federal penitentiary. The systematic nature of the alleged conduct eliminates most traditional defenses. Pattern evidence shows transactions occurring monthly over 3 years, each following similar concealment methods, each involving deliberate steps to avoid detection. Federal investigators describe the scheme as methodical and purposeful. Even worse for her legal position, the Charitable Foundation's own internal audit discovered irregularities 18 months ago. That audit triggered the investigation that led to today's crisis. Foundation trustees voted to suspend operations and cooperate with authorities after discovering what they termed shocking violations of fiduciary duty. Former Foundation trustee Michael Harrison testified under oath that Melania attended the board meeting where the audit results were presented. According to Harrison, she asked specific questions about legal exposure and requested immediate legal representation. That conversation, captured in meeting minutes, destroys her claims of surprise about the investigation. Defense attorney Patricia Evans, who represents high-profile defendants in similar cases, explains that federal prosecutors build cases methodically over years. They don't file charges until they believe conviction is virtually certain. The midnight filing suggests Melania's attorneys have finally seen the full scope of the government's evidence. We're witnessing the collapse of a defense strategy that was doomed from the moment she chose to make public denials about activities that left extensive documentary evidence. According to Evans, the emergency motion represents an attempt to prevent that evidence from reaching a jury, but federal rules severely limit grounds for excluding properly obtained evidence. The government's case includes bank records, email communications, foundation documents, sworn testimony from multiple witnesses, and forensic accounting analysis spanning 3 years. Each category of evidence independently supports the charges. Combined together, they create what prosecutors call an insurmountable case for conviction. 72 hours remain before the court must rule on her emergency motion. Those 72 hours may determine whether she faces trial or attempts to negotiate a plea agreement that could still result in significant prison time. Sources inside Melania's inner circle describe the scene as complete chaos. Emergency conference calls beginning at 6 and 8 a.m., attorneys shouting over each other about strategy disagreements, and what one insider called the most panicked atmosphere they had witnessed in decades of high-stakes litigation. According to a source speaking on condition of anonymity, Melania was observed pacing her residence library at 2:00 a.m., frantically reviewing documents with her primary counsel. This is the same person who just days earlier appeared composed during a carefully staged public appearance, projecting confidence about the legal proceedings. The contrast reveals everything. While she maintained her polished exterior for cameras, privately she was demanding answers her legal team couldn't provide. Multiple sources confirm she has been making calls to potential character witnesses, asking them to prepare statements on her behalf. That's not the behavior of someone confident in their legal position. Her lead attorney, David Richardson, reportedly resigned from the case during a heated 4:00 a.m. phone conference. According to sources familiar with the conversation, Richardson told other team members that the emergency filing strategy was legally reckless and potentially suicidal for his client. He refused to put his signature on documents he described as desperate and counterproductive. That resignation triggered what insiders call a complete meltdown in legal strategy. Richardson had been the voice of caution, advocating for a measured response to the government's allegations. His departure left more aggressive attorneys in control, leading directly to the midnight filing that legal experts universally condemn. Three separate law firms are now coordinating her defense, each with different theories about how to proceed. Sources describe strategy sessions where attorneys argue openly about fundamental approaches. One faction wants to fight every piece of evidence. Another advocates for immediate plea negotiations. The third pushes for procedural delays and appeals. This level of discord doesn't happen in well-managed legal cases. It happens when lawyers realize their client faces devastating exposure, and traditional defense strategies have failed completely. The human toll is becoming visible despite her attempts to maintain appearances. Security footage from her residence building shows her entering and leaving at unusual hours, avoiding normal patterns that might attract media attention. Neighbors report seeing multiple vehicles arriving for what appeared to be urgent meetings throughout the weekend. Even her normally reliable public relations apparatus shows signs of strain. Scheduled media appearances have been mysteriously canceled. Prepared statements have been delayed for what representatives call ongoing legal review. Her social media accounts, previously active and carefully curated, have gone completely silent. And it gets worse. Internal communications obtained through discovery reveal that her closest advisors have been discussing potential outcomes that include federal prison time. These conversations, conducted through encrypted messaging applications, show a level of concern that contradicts every public statement her team has made. One particularly damaging exchange shows her asking about asset protection strategies and international legal jurisdictions. According to former federal prosecutor Angela Torres, those are exactly the conversations that demonstrate consciousness of guilt and can be used against defendants at trial. The pressure is affecting her judgment in ways that create additional legal exposure. Sources report she has been contacting witnesses directly, attempting to coordinate testimony and align stories. Federal obstruction of justice statutes make those contacts extremely dangerous and potentially criminal. Her longtime personal assistant submitted her resignation this week, citing what she called an impossible working environment and ethical concerns about ongoing activities. That resignation removes a key witness who previously supported her version of events and creates another potential source of damaging testimony. Legal experts describe this pattern as a spiral of desperation, where each panicked action creates new problems that require additional desperate measures. Professor Linda Walsh from Columbia Law explains that defendants in her position often make their situations exponentially worse by refusing to accept the reality of their circumstances. The midnight filing itself appears to be the product of this chaotic internal environment. Sources familiar with the document's preparation describe a frantic process where different attorneys contributed sections without proper coordination or strategic oversight. The result is a legal document that contradicts itself and exposes previously protected information. According to veteran criminal defense attorney Marcus Chen, emergency filings should be surgical and focused on specific legal issues. Instead, Melania's motion reads like a comprehensive confession wrapped in legal arguments. Chen calls it the most self-destructive legal document he has reviewed in 30 years of practice. Behind closed doors, the woman who projected unshakable confidence is reportedly asking advisors about worst-case scenarios and exit strategies. Those conversations, if they become public through discovery, will destroy what remains of her public credibility and provide prosecutors with additional evidence of criminal intent. The emergency motion designed to save Melania from prosecution just handed federal investigators their strongest evidence yet. Legal experts describe the filing as a comprehensive roadmap to additional criminal charges that prosecutors didn't know they could pursue. Constitutional law professor Janet Richards analyzed the 47-page document and identified 14 separate admissions that contradict Melania's previous sworn statements. According to Richards, each contradiction represents potential perjury charges that carry their own federal penalties. The motion attempting to dismiss the original case has created grounds for an entirely new prosecution. Think about what that means. Her legal team filed an emergency motion that accidentally confessed to crimes prosecutors hadn't even alleged yet. The specific language in the filing acknowledges that Melania had direct knowledge of Foundation financial operations, participated in decision-making about fund transfers, and maintained ongoing communication with co-conspirators. These admissions destroy the ignorance defense that formed the backbone of her previous strategy. Federal prosecutor Maria Santos, who secured convictions in similar high-profile cases, explains that defense attorneys are trained never to make factual admissions in dismissal motions. The standard approach involves challenging legal theories while preserving all factual disputes for trial. Melania's motion abandons that protection entirely. Even worse, the filing reveals previously unknown details about her involvement in concealment activities. Her attorneys describe efforts to modify documentation, coordinate witness testimony, and structure transactions to avoid detection. These descriptions, intended to justify her actions, instead provide prosecutors with detailed evidence of obstruction and conspiracy. The precedent for this kind of strategic disaster comes from the 2019 Morrison case, where emergency filings created additional federal exposure that resulted in 34 years of prison time. Morrison's attorneys, like Melania's team, panicked when facing serious charges and filed desperate motions that made everything worse. Legal analyst Robert Chen reviewed both cases and found striking similarities. Both defendants maintained public innocence while privately coordinating increasingly desperate legal strategies. Both relied on emergency filings when traditional approaches failed. Both ended up providing prosecutors with evidence that secured convictions on charges beyond the original allegations. The timing makes her position exponentially worse. Federal sentencing guidelines include specific enhancements for obstruction activities that occur during ongoing investigations. Every attempt to modify her story, every effort to coordinate with witnesses, every emergency filing that contradicts previous statements adds mandatory years to potential sentences. Her motion asks the court to exclude evidence based on procedural technicalities that don't actually apply to her situation. Federal rules of evidence allow extensive latitude for admitting relevant documents in criminal cases. The exclusions she requests are typically granted only in the most extreme circumstances involving constitutional violations. None of those circumstances exist here. The evidence was obtained through valid warrants, properly executed search procedures, and voluntary cooperation from witnesses. Her attorneys are asking the court to exclude evidence simply because it proves their client's guilt. That's not how federal courts operate. Court deadlines create impossible choices for her legal team. They have 48 hours to respond to government objections to their motion. Any response requires them to defend admissions they never should have made in the first place. Staying silent allows prosecutors to use those admissions without challenge. Criminal defense veteran Sandra Torres describes this as a legal checkmate situation. Every possible move creates additional exposure while failing to address the underlying problems that triggered the emergency filing. According to Torres, defendants in this position typically begin serious plea negotiations within days. The systematic failure of each argument in her filing demonstrates how desperation overrides professional judgment. Her attorneys challenge evidence they can't exclude, make admissions they can't retract, and reveal information they should have protected. Legal experts describe the document as a masterclass in how not to defend a federal criminal case. Federal investigators now possess admissions, contradictions, and detailed descriptions of criminal activity that strengthen every aspect of their prosecution. The emergency motion designed to end her legal troubles has instead accelerated her path toward federal conviction. Judge Patricia Wilson, who oversees the case, has set oral arguments for Friday at 2:00 p.m. Legal observers expect devastating questioning about the contradictions between Melania's public statements, previous sworn testimony, and new admissions contained in the emergency filing. Those contradictions will be preserved in court transcripts and become permanent evidence for any future prosecution. The trap that was set by her own desperation is about to spring shut in the most public forum possible. Melania's legal crisis is creating shockwaves across three separate federal investigations that were previously considered unconnected. Her midnight filing referenced documents and relationships that prosecutors in the Southern District of New York didn't realize were part of her foundation activities. According to sources familiar with the investigations, her emergency motion inadvertently revealed connections between her charitable foundation and offshore financial arrangements that are under scrutiny in an entirely different criminal probe. We're talking about a web of financial relationships that investigators now understand extends far beyond what anyone previously suspected. The timing couldn't be worse for her potential allies. Republican leadership sources indicate that her legal troubles have become politically radioactive just as midterm campaign season intensifies. Former supporters who once defended her public image are now maintaining careful distance from any association with her legal strategy. Senator Patricia Williams, who previously called allegations against Melania politically motivated, issued a statement through her press secretary emphasizing that she has no knowledge of the legal proceedings and believes justice should take its course. That's not support. That's abandonment. The cascade effect extends to the Trump Organization, which shares financial advisors and legal counsel with Melania's foundation. Her admissions about coordination between entities create new exposure for related business operations that prosecutors are now examining with fresh scrutiny. Think about the implications. Federal investigators are discovering connections they didn't know existed between cases they thought were separate. Melania's desperation to escape one prosecution has accidentally provided roadmaps to multiple additional prosecutions. The media attention surrounding her midnight filing has intensified scrutiny of every aspect of her financial activities. Reporters who previously focused on political stories are now pursuing financial investigations that reveal previously unknown business relationships and transaction patterns. Financial institutions that processed her foundation's transactions are receiving federal subpoenas triggered by revelations in her emergency motion. Banking executives describe the requests as comprehensive and urgent, suggesting investigators believe they are pursuing time-sensitive evidence of criminal activity. Her legal crisis is forcing choices on people who previously maintained neutrality. Former foundation board members are hiring separate legal counsel and distancing themselves from her defense strategy. These individuals, who once provided character references, now refuse to comment publicly about her case. The isolation extends to her social circle, where longtime friends report feeling uncomfortable about any association with ongoing federal investigations. Social events that once included her are being restructured to avoid any appearance of impropriety or coordination. International implications are emerging as foreign governments reassess their relationships with Trump-related entities. Sources familiar with diplomatic communications indicate that several countries are suspending business dealings pending resolution of the federal investigations that Melania's filing has inadvertently expanded. Corporate partnerships are dissolving under the pressure of association with federal criminal investigations. 3 major suppliers terminated contracts with Trump Organization properties this week, citing what they called unacceptable reputational risks following the latest legal developments. The foundation itself faces immediate shutdown as federal investigators expand their probe based on information contained in her emergency filing. Board members voted unanimously to suspend all operations and place remaining assets in escrow pending legal resolution. Legal experts predict that within 30 days, her desperate attempt to escape prosecution will result in federal charges against individuals who were never previously under investigation. The domino effect she triggered is exposing years of coordinated financial activities that prosecutors describe as a criminal enterprise. Campaign finance violations are now being investigated based on foundation transactions that her filing revealed were coordinated with political activities. Federal Election Commission referrals are expected within days, creating additional criminal exposure for multiple participants. The trajectory is clear. What began as an attempt to dismiss charges against one person has become a federal investigation into systematic financial crimes involving dozens of individuals and multiple entities. Her midnight filing will be remembered as the moment a limited prosecution became a comprehensive investigation into organized criminal activity.